Good morning, everybody. Happy Monday. Well, what's the subject for today? Well, we're going to be talking about the K-1 fiancé visa and the procedures in which to do it, and what some of the pitfalls are, what some of the misconceptions are, and so forth, so that you'll have a better idea of how, when, and where to do a K-1. Okay, so I'll talk about the K-1, and then after I will answer whatever questions you guys have. And if there are none, well, then we'll wait till next time. Okay? So the K-1 is the fiancé visa. Okay? And the fiancé visa can only be done if the petitioner is a U.S. citizen. If the petitioner is a lawful permanent resident, it's not happening. Okay? Now, it's possible that the lawful permanent resident petitioner can then decide that they want to become a U.S. citizen, and then once they become a U.S. citizen, then they can petition the fiancé. Another thing, which may seem obvious, but I have a lot of clients that this issue comes up, is if they get married, whether it's inside the U.S. or outside the U.S., then they can't do the fiancé petition anymore because they're no longer a fiancé. They're a spouse. Okay? And so they need to remain as a fiancé the entire procedure and the entire time to do a fiancé petition. Okay, so what is the procedure that normally is done when you're doing a fiancé petition? Well, first things first, you of course have a fiancé, okay, that's outside the country, and you are a U.S. citizen. Note, you're not going to do a fiancé petition while inside the country. That just doesn't happen, because then you would just have to get married and then just do an adjustment, okay? So for all intents and purposes, a fiancé petition is when the beneficiary is outside the country and you are inside the country. And then what will happen is you will petition the fiancé, and it will first go to USCIS here in the United States for approval. It doesn't just get sent to the consulate as with some other types of visas, okay? You will then send the whole petition to USCIS. Now, what are some of the basic requirements? One, you have to have physically met within the last 2 years before the petition is filed. Okay? And I have clients that say, well, I've known this person for the last 5 years and we've communicated every day on Skype and we love each other and this and that, and I just haven't been able to get off work to go visit personally. Well, immigration doesn't care about that, okay? You have to meet personally. It doesn't have to be in their home country. You could meet in between, okay? But just save evidence of that. And then this, of course, will be a subject for another video, but there are ways of doing a waiver of the in-person meeting requirement if needed, okay? That will be the subject of the next fiancé visa. But for now, for all intents and purposes, you have to meet in person. You need to make sure when doing the fiancé petition that you, the U.S. citizen, will be able to put it all together and show that you make a sufficient amount of money so that the beneficiary will not become a public charge, okay, or otherwise they're inadmissible. And speaking of inadmissibility, if the beneficiary has any grounds of inadmissibility, just like if they, had the green card, if they have a criminal history, if they have unlawful stays in the U.S., if they have fraud, if they have, certain medical issues, then they're inadmissible and you may need to do a waiver. But assuming that's not the case, it all goes to USCIS, it takes some time, and then hopefully it's approved, and then it will go to the consulate, okay? and then the consulate will open up their file. They will then get in contact, set up an appointment, and ultimately, the fiance will go to an interview at the consulate, and if it's approved, then they come inside the U.S., okay? And once they come inside the U.S., you will then have 90 days in which to get married. Now, if you decide not to get married for whatever reason, I've had this happen over the years a lot. The fiance wants to, years later stays or overstays, marry someone else or has some other employment-based visa once they come here on a K-1. The law is that once you come on a K-1, you cannot adjust status any other way other than through the person who petitioned you. And while there are some exceptions to that, that's the general rule, okay? But assuming you marry within 90 days, then the adjustment is filed, and if it's all approved, you end up getting the green card. Okay, that's how the fiancé visa works in a nutshell. Okay, so hopefully that all made sense, and hopefully that will help clarify some issues. I know a lot of people, instead of doing the fiancé visa, they literally ask me this. They go, well, I can't stay apart for 9 months from my fiancé, so I want to come into the U.S. on a visitor visa, and then I want to get married and stay there forever. Well, obviously that's fraud, because the visitor visa is not meant for that. And I tell them, I go, look, realistically, that's not a good idea because, of all the various rules and intent and fraud and this and that, you can't bypass the system like that. It would be better just to do the fiancé visa, make sure it's done right, and then you don't have to worry about anything at the other end. Okay? All right. So let's scroll back to the beginning and let's see if we have any questions. Hope everybody's doing good on this fine Monday morning. Okay, just a minute. Be patient with me while I go down and see if there's any questions. Now would be the time if you have questions to ask. Hey, okay, this is from Yuval. Hey, I got 5 years bar from the States. Well, that means you were likely expeditedly removed. Okay, meaning that you came into the U.S. and for whatever reason, they turned you around and expeditedly removed you. Maybe you had fake papers. Maybe you didn't have a proper visa. Maybe you didn't show sufficient intent. Whatever it is. So there's a couple things. If it was just turned around with nothing else and you got the expedited removal, then of course you can just wait the 5 years. And that doesn't mean you can just magically come back in again. You still need to qualify for a visa to come back in. You could also do a non-immigrant waiver the day after you're expeditedly removed, okay? Which basically is a nice way of saying deported very fast. So, the waiver will waive this if it's granted, but I need to know the basis of why you were expeditedly removed in the first place, because that might give rise to other grounds of inadmissibility that I need to know about. Okay, let's see. Yuval, can you help? I'm an Israeli. This is from the same guy. Well, yeah, I help with these type of stuff all the time. But again, I need to know why you were expeditedly removed. If you're from Israel, and you have business that does business with the U.S., you can get an E-1. Okay, there's other types too, but I need to give you a consult. Okay. Let's see what we have. Okay, this is from Morale. What should I do after second inquiry to I-45 asylum base and nothing happening 1 year and 5 months? Okay, that's a pretty long time. Now, I'm assuming, Morale, that you got an approved asylum. Okay, that everything is hunky-dory on that basis. And I know that, depending where you are, there were some issues with, Trump snapping his fingers and saying that you can't go forward which is silly, ridiculous, and so forth. But if nothing has happened, you might have to do what's called a writ of mandamus. I think you found that inquiries are kind of useless. Okay, we could have this conversation 10 years from now, and you could say, well, it's been 10 years. I did an inquiry, and they said just wait. A lot of times they need pressure, and they being USCIS. And one of the ways to do that is a writ of mandate, where you file a suit in federal court, writ of mandamus, which forces them to make a decision. Now, it doesn't mean they can say yes, or it doesn't mean that you're forcing them to, approve it, because they can certainly make a decision and say no. But as an administrative agency, they have a duty to adjudicate cases. And if it were up to them, your file would be sitting there forever because they're not motivated. So I help motivate them. Okay, the writ of mandamus goes in front of the court. The USCIS hires the U.S. attorney who represents them. The U.S. attorney looks at this and go, oh my God, this 12, 15-page application has been sitting there doing nothing for a year and a half. It's hard for the U.S. attorney to justify that in front of a federal judge, because the first thing the federal judge is going to go, counsel, why hasn't this been adjudicated? Why is it taking so long? And so I can tell you, over the 30-some years I've practiced, 3 decades, holy cow, time flies when you're having fun. Of the decades that I've practiced, I've done quite a few writ of mandates. And minus a couple, every single one has resolved itself before the U.S. attorney stands in front of the judge, because they just don't want to. So the U.S. attorney, they go to their client, which is immigration, and says, just adjudicate this thing. Magically, after I file it, and it gets time for the U.S. attorney to answer, the government to answer, I'll get a notice that it's been approved, or whatever we're waiting for will magically come through the mail. So that's the way. Okay, you don't have to wait forever. Given that, it's not cheap to do a writ of mandamus. I'm telling you that. Okay, it's a lot of work, but it's either that or just wait and twiddle your thumbs forever when you're entitled to the green card. Okay. Okay, let's see what else we have. Okay, just a minute. Okay, just a second. All right. Yuval, you asked a follow-up question, but you did not tell me why you were inadmissible in the first place. Okay, so you can always call my office and make an appointment for a consult. Okay. I mean, you need to call my office, 562-495-0554. Okay. Let's see. Well, Yuval, you're like piecing it together as we go here. You're saying that your visa was overstayed for 30 days. So something's not making sense here, because you get the 5-year bar when you're expeditedly removed. You're expeditedly removed when you try to enter the U.S. Okay? So you need to just call my office. I'll be able to clue you in, or you can email me. This is from A. That is a very short name. Is K-1 and the Trump travel ban? It's not the K-1, okay? Believe it or not, he has not tried to abuse his power by stopping Fiancé petitions. I mean, I'm saying this now, maybe tomorrow he will, but it's people from certain countries, and they are denied the ability to come into the U.S. regardless of what they apply for, whether it's the K-1, the H-1B, the E-2, the E-1, the L-1. I mean, I could go on, okay? So it's not the visa category that has been banned. It's people from certain countries. Okay. Alrighty. Let's see what we have. Yuval again. This is like the Yuval show. You say you've heard about the waiver for the B1, B2. Well, I told you. It's a non-immigrant waiver. And a non-immigrant waiver will waive all grounds of inadmissibility other than security reasons for a non-immigrant visa. But that doesn't mean that just because you can do it, that it will be granted. Okay? Again, if you... I mean, you have to be realistic here. Let's assume that you tried to come in and they say you can't come in because you overstayed for 30 days. Okay. And then you do a waiver of the 5-year bar. And let's say the waiver goes with a B2 petition. They might be inclined to grant the waiver, but they might be inclined to deny the B2 petition because you would have to prove your intent to leave once you are done. And if you overstayed for 30 days before, they're not going to believe that. Especially if they caught you, okay? I mean, especially if that's how they caught you and removed you. So when you are barred, I mean, if you want to be realistic about this, Yuval, when you are expeditedly removed and you do a waiver, you need to have a better visa to try to come in on than a B1 or B2, okay? Like a business visa. And you're Israeli, so do you have a business, okay? There's different types of businesses. Do you have a company that will sponsor you here? What is your education? Okay, so there needs to be more work done on the visa side of it to give a more realistic chance of the waiver being approved. Just because there's a waiver doesn't mean you're coming in. Okay, you might have a fantastic waiver, okay? But that doesn't mean the visa will be approved. So the realistic way to do it is to have a good visa and a good waiver. Both. That's how you're going to get back in, realistically. Okay. Let us continue. Alrighty. Well, I think we've reached the end of our time together. I hope everybody has enjoyed one way or another, or learned a thing or two. If you want to consult, just give me a call, email me, all the numerous ways that you can contact me. Everybody enjoy the rest of your day. Okay, signing.